Welcome to the Texas Commercial Litigation Podcast with J. Robert Arnett II.
Hello, everyone, and welcome back to the Texas Commercial Litigation Podcast with J. Robert Arnett II, principal of Carter Arnett in Dallas. Bob has more than 35 years of experience handling complex business, intellectual property, and real estate disputes in Texas and federal courts nationwide. I'm Sean O'Connor, and today we're examining commercial lease litigation in Texas and how enforcement, defaults, and high-stakes disputes are handled in court. Bob, good to see you.
Good to see you.
When a commercial lease dispute escalates into litigation, what types of conflicts most often bring the parties into court?
Non-payment of rent, usually. There are some other things that happen. Sometimes there are disputes about exclusivity provisions that tenants may have. In other words, I get to be the only Tex-Mex restaurant in this shopping center, and then the landlord, lets somebody else put in a restaurant. It may be that the other tenants are complaining about the tenant's conduct of business, and there's provisions and rules, the rules and regulations of the property that are potentially being violated, or structural issues. If there's been some casualty loss, there can be issues about what's the landlord's obligations to restore the property, what's the timetable for that, what's the tenant's recourse if it's not done or not done as quickly as it should be. But by and large, it's non-payment of rent.
Yeah, that's the big one. Makes sense. How do Texas courts typically interpret lease provisions governing defaults or cure rights and termination?
Well, typically they follow the contract. The contract will generally have provisions about, what we call non-monetary defaults. In other words, aside from the non-payment of rent, there's, a whole host of covenants and agreements that tenants make, requirements that they have to comply with. And if they don't comply with them, then, most commercial leases have a provision requiring written notice from the landlord to the tenant, and then a period of time for the tenant to correct the problem or cure the problem. And then if they don't do it within that period of time, then that becomes an event of default and triggers the landlord's rights to exercise some remedies.
I see. If we're talking about disputes involving substantial rent arrearages or CAM reconciliations, how does the financial structure of the lease influence litigation strategy?
Well, it influences it in the sense that if it is, for example, if it's a CAM reconciliation issue and it's a long-term lease with substantial rent, one of the things that the parties have to look at is the fact that, unless one side or the other has good grounds to terminate the lease, they're going to be living with each other for the foreseeable future. And, that may influence whether they want to try and resolve it without litigation, or, follow some other path. Sometimes, leases require arbitration of CAM disputes. So that may be a different track that may be a better resolution than going and having a jury trial over it, because it's hard to envision a more boring topic for a bunch of jurors than to sit there and listen to a couple of accountants argue about, this cost or that cost, or whether that was properly attributed to the tenant or not. So, that's something to consider.
Right. I know that personal guarantees are common in commercial leasing. How do guarantor provisions shape both leverage and exposure once litigation begins?
Well, so, the landlord can, let me back up. So, most leases are pretty much unqualified absolute guarantees, or come with absolute unconditional, unqualified guarantees. Uh, in other words, that gives the landlord the option to sue both the tenant and the guarantor, or just the tenant or just the guarantor, and that can make a difference if one or more of those target parties is likely to file bankruptcy, or has filed bankruptcy. If the tenant has filed bankruptcy, then you can't sue the tenant in state court. You're going to have to file a proof of claim in the bankruptcy court, and potentially seek some relief from the bankruptcy court regarding the lease. But that doesn't stop you from going after the guarantors. You can sue the guarantors in state court, or you can wait to see how the bankruptcy plays out, and then sue the guarantors. And then, the other factor is who's solvent, who is answerable, who can answer a big dollar judgment. That impacts whether are going to be looking to the tenant, you're going to be looking to a guarantor. And, if you eventually get a judgment against people that don't have any money, it's a nice piece of paper to hang on the wall, but it really doesn't advance the ball for the client.
Yeah, yeah. Force majeure clauses and operating covenants have received increased attention in recent years. How have courts approached those provisions in contested cases?
Well, force majeure clauses generally are pretty strictly construed. In other words, the court's not going to give you an out based on force majeure unless it's really within the four corners of the clause. There was a little bit of play in that because of COVID, because some force majeure clauses didn't specifically contemplate that there would be government ordered shutdowns, and so the courts became a little more flexible with respect to that, if they thought it was justified. The operational covenants, um, I frankly haven't seen too many of those. And what those are is it's a covenant by the tenant that they're going to stay in operation because the landlord doesn't want, particularly if they've got a shopping center, or a mall, they don't want an empty store.
Yeah.
They want traffic, they want activity, and but at the end of the day, the tenants, there's not really much in the way of additional damages that arise from those, and I have not seen say the tenant has decided, okay, I'm losing money on this spot. Yeah, okay, I'm stuck with the lease, but I'm going to just go dark here, uh, and I'll keep paying the rent, but I'm going to go dark so I don't continue to have operational losses in this facility. I have not seen a court say, no, you have to go in there and operate and lose money. Haven't seen that, because they're answerable in damages. There may be some additional damages that the landlord could prove, in addition to the rent. I say, because a lot, shopping center leases will typically have base rent and then additional rent, which is based on, a percentage of revenue, for example. And so if the tenant's not operating, they're not generating revenue, there's no additional rent. And they can say, well, we have additional damages based on what you should have earned that we would have had a piece of.
When a landlord does seek injunctive relief or possession in a commercial setting, how does that process differ from purely monetary claims?
Well, typically landlords don't necessarily need to seek injunctive relief in order to regain possession. They have, in Texas, the right, if the tenant is delinquent on the rent, to change the locks, to just lock the tenant out of the space. And that's typically what they do. The tenant has a statutory right to regain possession, but they've got to come current on the rent. So I've seen injunctive relief sought the other way. In other words, landlord locks the tenant out. Tenant says, okay, here's the back rent. And the landlord still don't want to let him in, seek an injunction to get back in there. Or, if the landlord has locked the tenant out and there's, typically the landlord has a lien on any personal property of the tenant that's in the space. But there may be a lot of property that's in there that doesn't belong to the tenant. Like, for example, leased equipment, or um, things that are there on consignment. So I've seen injunctions from tenants trying to get back into the space so that they can, deliver possession of, leased equipment, for example, to the lessor or the actual owner of it that wants it back. Um, so, as I said, it's not really necessary for the landlord to seek injunctive relief in order to gain possession or dispossess the tenant. Um, there may be occasions when the landlord seeks injunctive relief to, without kicking the tenant out, to stop the tenant from doing something the tenant's doing that breaches some lease covenant. That's a possibility.
I see. In larger commercial developments, with lenders and multiple stakeholders, how does the presence of those financing arrangements affect enforcement decisions?
Well, so in a couple of ways, and you see this more commonly in equipment leases than in real property leases,
Hmm.
is the idea that, and this becomes really important if the tenant winds up going into bankruptcy, is whether the lease is a true lease, or they sometimes call it a bona fide lease, or is really a disguised financing arrangement. So if it's really, kind of like the rent to own thing, uh, you rent it for, you rented this piece of equipment for 3 years. And at the end of the 3 years, for some nominal amount of money, you can take title to it. Well, uh, that's really a purchase. That's not
Yeah.
really a
Lease.
lease. So that can affect it. I have seen that to some extent with real property leases, particularly where the lease is, where it's been sold and then leased back. Property's been sold and then leased back, and uh, the lease, the rent payments are actually amortized, like mortgage payments, an amortization schedule, uh, instead of simply, what's fair market rent for this particular piece of property. So, uh, and those come into consideration about whether you want to terminate or not. And sometimes there are limitations in those kind of leases about the ability to terminate. Um, if it really is designed for the tenant to wind up owning it at the end of the lease.
Right. Well, so from a corporate counsel perspective, right? Corporate counsel managing a significant lease dispute, what broader considerations should guide whether the matter is resolved through negotiation or, taken through to trial?
Well, I think there's a lot of factors that go into that. It depends on who your tenant is. Do you have guarantees? Who are the guarantors? Is the tenant solvent? Are you better, are you better off trying to resolve it and keep the tenant in the space? It's also, a factor is if the tenant if the tenant either vacates on their own or you terminate their right of possession, how long is it going to take you to get somebody else in there? Sometimes there are, long-term leases, uh, and the building has been a build to suit uh, project. Think of the standalone buildings that a lot of fast food places have. In-N-Out Burger, Starbucks. They have a ground lease, and the store was built, to be a Starbucks or to be an In-N-Out Burger. And for the landlord, a big question is, if I have to kick these folks out, how long is it going to take me to renovate this and find another tenant? And how much is it going to cost me to make the premises suitable for somebody else? So, those are considerations.
Yeah, I was just, it's interesting because I was just reading about, the trend of, some of the big drugstores that have closed, the chain stores, CVS is the Walgreens of the world, and, uh, and how that's, playing out as a dynamic with, in leasing, Right. And this, whether it's, do these get repurposed or do they tear it down and build something to suit, and it's not a direct correlation to what we're talking about, but it just, uh, some of the same factors come into play in terms of, value
Yeah.
and what,
Right. Right.
yeah.
Yeah. And I guess another factor that, I mentioned a little bit earlier, but it's important in this context as well is, is there the prospect of a bankruptcy in the offing? Because in bankruptcy court, leases get treated differently
Right.
than, other claimants. You can be stuck with a non-paying tenant, in bankruptcy court, uh, and the tenant has a certain period, or the now debtor has a certain period of time to decide to either reject or assume a lease. And, sometimes debtors will try and string you out and get extensions of that, where you may be a year into it not getting any rent, and the tenant still has the option, if the court lets it go on that long, to still assume your lease and keep you bound to the terms of the lease. Now, I mean, if they do assume, they have to cure all the past monetary defaults, but they may be able to do that if they've been, if they're using the bankruptcy as something that gives them time to get refinancing in place, or additional equity infusion, or whatever it is that they're going to do. They may do that to you, and you may be stuck.
Yeah. Yeah. They use it strategically like that. Interesting. Well, hey, we're out of time, Bob. And I know we'll talk again soon. It's good to see you.
Good to see you. Good to have another good conversation.
That's it for today's episode of the Texas Commercial Litigation Podcast with J. Robert Arnett II of Carter Arnett. To learn more about Robert and his firm's work in business and intellectual property litigation, visit their website, carterarnett.com. I'm Sean O'Connor. Thanks for listening. And remember, like the episode, review the episode, subscribe to the podcast so you don't miss any valuable information. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.